where do you start now, letter of demand? You've mentioned few options, VCAT or Magic Court and so on, but you don't, and county court. And how do we decide the correct forum?
Yeah, that's determined a lot of the time by how much is owed. So if it's over 100,000, you'd be seriously looking at issuing in the county court, because the magistrate's court limit, subject to exceptions, is 100,000. So anything above that, you'd have to be looking going into the county court, which commensurately with the higher jurisdiction then may result in the whole thing costing extra. So all that needs to be considered and factored in at the start is that if you're chasing a $10,000 debt and it's going to cost you $5,000 to get it, then sometimes there may not be the economy to do that.
Mm-hmm. And what happens if the debtor doesn't attend courts in answer to a summons for an oral examination? That's
something that I sort of deal with more on a day-to-day basis. Mm-hmm. As you say, sometimes they don't attend. I've had a few cases that they haven't attended in answer to a summons of examination. There is a power of arrest. There is a power that the court has to instruct the Sheriff's Office to arrest a person for the purposes of being brought before the court. I think that generally they're quite reluctant to exercise that power. They might send the person a warning letter and say, next time we will send a sheriff out, you must attend. They'll reschedule a new date. So they'll give that person maybe another chance. If they don't attend on the second occasion, then I think that's more likely that the Sheriff's Office would get involved.
Most of the time they would attend. They can miss one or two, but they would eventually attend.
Right, I guess at that stage, probably if someone doesn't have legal representation or advice, it's better to get advice at that stage. Am I correct?
Sure. I think it's always really better to get advice as early on in the stage as what you can, because sometimes what can start off as a very simple thing that somebody may well be able to start off themselves, they start getting a bit in over their head and start making mistakes. And sometimes mistakes are remediable and sometimes they're not.
But before you get to the summons for oral examination, you would have had to have issued somewhere and you would have had to have gotten an order to allow you to do that.
Right, right. Do you want to elaborate a little bit more about that process?
Yeah, so on any debt, it starts with a statement of claim being issued, whether there is an application in VCAT, a statement of claim, the Magic Court, or written in the County Court or the Supreme Court. Then depending on which court you're in, there's a time period allowed to put in a defence. If the person doesn't put in a defence, then the applicant can apply for summary judgment application, which means that you will receive the judgment by default. And then with that order, you then go and enforce that order through a sheriff, or you go through and do a summons for oral examination. If the debt is defended, which we would like it to be defended, because if a debt is undefended, you can always the person can always make an application later on to have the debt defended.
Right.
Most of the times the court will exercise the jurisdiction to allow them to do that if there's a bona fide defence. So if it is properly defended and they lose, and you've got a court order, and then you can you enforce judgment against them.
So once you win, or if you win your case and a judgment or an order is obtained, how does the client ensure that the dollars actually end up in their pocket? Because
that's not the end, isn't it? Just because there is a judgment. That's very clear to
it's
get.
Like three-quarter time.
Right, right, yeah, so, yep.
That's right. Unless it's actually at a full-blown hearing and there's an order made by a magistrate, then that order usually stays in place. But if it's an undefended matter and you get a default judgment, it's an order of the court, it's a judgment that the court will say that this person must pay that person money, but it can be set aside. Because, for example, that person may have not filed a defence to the claim for illness or mental health issues or that type of thing.
And those are the defences.
And then they may well have a defence.
Right. They may have a valid
They might have a defence.
Yep.
And so they've lost that chance to do it. So the court will often, particularly if the other party is not represented by a legal practitioner, the court will often allow that person another go to file a defence, and then the process then starts as usual after that.
Right. So just take a step back again. So let's say at some point there is a judgment, and it's not paid again just because there's a judgment. What's the next step from there?
So we're going through the process. We've got an order, and let's say the order was properly defended, like your question was, and how do we then ensure that that money is paid?
Yes.
Unfortunately, there isn't anything that will guarantee payment. So there are steps that you take. So, for example, like a bankruptcy, if it's a natural person, if it's a normal person, you issue a bankruptcy notice. If the person doesn't comply with the bankruptcy notice, then they'll be made bankrupt. A trustee will take possession of any assets that they have, and they'll try to sell those assets. And if there's any recovery on it, that recovery comes back to the person that obtained the order.
Right.
If it's a company, then you issue a stat demand. So bankruptcy is one option. Second option is you can do a garnishee order, which is if the person is working and they're earning over, I think the minimum is 50,000. That you can garnish a portion of their wage to pay that debt.
That's important to understand, isn't it? So using a garnishing order, you can directly tap into that person's salary.
Correct.
And a particular portion.
Correct.
Yeah. And how do we decide the portion depending on the salary, I guess? Or?
So you have to do a summons for oral examination.
Right.
Beforehand.
Is it another process?
No, it's a process before that process.
Right. Okay.
So you do summons. So then you know what they have, what they're earning. It's
right.
under oath. It's in court.
Oh, so they have to disclose that.
You have to disclose that.
Right.
Correct.
Right.
And then based on that information, the magistrate will decide what is the appropriate figure to garnish off their wage.
We will be taking a short break now, and we will be back soon.